You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast. My name is Adam Diament, a registered patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This is episode 144. Can you patent genetic resources and traditional knowledge from indigenous people? Now, what does patenting traditional knowledge and genetic resources of indigenous people mean? First, let me say what it doesn't mean. You can't patent knowledge. That's not a thing. You also can't patent human genes anymore, at least not in the U.S. And even when that was possible, it's not what most lay people think it meant. No one could ever say they own the gene that's inside of your cells. What this does have to do with is indigenous people, and that's why I'm bringing this up. There's a new treaty that was just signed under WIPO. WIPO stands for the World Intellectual Property Organization, and various countries are part of WIPO. And the treaty is the WIPO Treaty on Intellectual Property, Genetic Resources, and Associated Traditional Knowledge. This really comes into play for medicinal type patents, and maybe what you know is that for a lot of medicines or treatments, it doesn't just randomly start in a laboratory somewhere. Sometimes there's an indigenous tribe community somewhere that's been using some plant for thousands of years to treat something, and they may not know how the plant works or what chemicals are in the plant that have healing properties. They just know that this plant helps in some ailment. Then some pharmaceutical company comes along and they hear about this plant and they take it and they do all kinds of experiments, isolate different compounds in the plant, and they figure out what chemical is in there that has medicinal qualities, and they turn that into a drug and patent the drug. Now maybe you're thinking, how can they do that? I thought you told me you can't get a patent on a product of nature, and that's true, but the product of nature is the naturally grown plant that happens to have chemicals in it. But what isn't the product of nature is the isolated, that's the key word, isolated chemical that has the medicinal qualities. So even if there's a patent on the chemical, it doesn't mean that someone can't go out and eat the plant to get the healing properties of the plant. But it does mean that the pharmaceutical company may have the rights to the isolated compound. But there are also method patents. So even if a chemical exists or even patented, if you have figured out that this chemical or plant treats some condition that no one had thought of before, you can get a patent on the method. So maybe you figured out if you take this plant and rub it on your head, you can get a patent for something like a method of treating baldness comprising the step of rubbing the doohickey plant on your head. Theoretically, that's possible. So it doesn't mean that they own the plant or that other people can't sell the plant, but someone else can't sell the plant if the plant comes with instructions to rub it on your scalp to grow more hair, because that would be patent infringement. Now, you may disagree with whether this should be allowed at all, but as of now, that's just how the patent system works, and you can get patents on isolated compounds. The people that don't like it when pharmaceutical companies get patents on things that are already known by indigenous people, they call this biopiracy, so you might hear that word. There's a couple problems with this, and WIPO want to try to fix some of it. One is that if you file a patent application, you have to provide knowledge of what's publicly known information about things that might be relevant to patentability. That's really hard to do if what is known is really just oral knowledge about plants from indigenous groups. There's nowhere to submit the information of, I talked to the medicine man in a tribe in Bolivia, and he told me they rub this plant on wounds, and the wounds heal quicker. And when the patent office is searching databases to find out whether a compound is new and non-obvious and patentable, they're just not going to be able to do this on a computer search that has this information. A couple of real-world examples are wound healing properties of turmeric, which has been used in India for a long time. There's also patents related to the neem tree extracts, which was found in India, and it's been used to reduce tooth plaque, treat lice, it might reduce blood sugar levels, heal ulcers, and kill bacteria. There's the African Hoodia cactus, which has been known to curb hunger and used by the San people in southern Africa. The South African Council for Scientific and Industrial Research realized that the plant was marketable and patented its use as an appetite suppressant without recognizing the San people's traditional claims to the knowledge of the plant and its use. That patent was sold to Unilever, which marketed it as a diet supplement. There was a case where someone got a plant patent for supposedly a new variety of ayahuasca vine that was found in a cultivated garden in the Amazonian rainforest. And the indigenous people didn't like how some outsider was able to get a patent on a plant that they considered sacred. If you want specifics on that case, and I recently talked about plant patents in a previous episode, you can look up the plant patent 5751, and if you just Google plant patent 5751 ayahuasca, you'll see lots of articles about this whole situation. So what does this new treaty do? In the U.S., you're already required to disclose information material to patentability, but now there are going to be some additional things that happen if the invention is based on a genetic resource, which basically means plant or animal or something living, but not human for this definition, or associated traditional knowledge. And traditional knowledge means knowledge that's been passed down from generation to generation in a community that often forms part of a cultural or spiritual identity. The new requirements are that the applicant has to disclose whether their inventions are based on genetic resources or associated traditional knowledge, the country of origin and the indigenous people or communities that provided the associated traditional knowledge. And there's a remedy that if they don't disclose that information in the patent application, if you fail to disclose it, that countries that are a party of this treaty create an effective and proportional sanction for failing to disclose, but it can't, and maybe this will seem strange to you, revoke the patent based on the applicant's failure to disclose absent some additional evidence of fraudulent conduct or intent. So what might that be? Maybe it means that there's a required license for profit sharing with those indigenous groups. The treaty also says that a country that is part of the treaty may establish information systems, such as databases of genetic resources and traditional knowledge, in consultation with indigenous people and local communities. It says may, not required, so I'm not sure how much teeth this really has. And honestly, I'm not really sure that this treaty does that much. So someone has to disclose whether they got this from indigenous people or a local community, but it doesn't stop them from getting a patent. It doesn't force the owner of the patent to compensate the indigenous group. It doesn't require them to get permission from the indigenous group. It's really just forcing people to be more upfront about where they got the information from, about what they're trying to patent. And if they're not upfront in the application process, there can be some punishment. I guess it's better than nothing, and maybe would help in the search by a patent examiner, because maybe the patent examiner might be looking for publications in scientific journals or published patent applications, but isn't necessarily going to be looking at databases of indigenous traditional knowledge. But if the applicant states that this new chemical comes from plants in a certain country, and a tribe has been using plants for certain medicinal purposes for a long time, then the examiner may take some extra time looking through databases that have information about traditional knowledge and genetic resources to determine whether their claimed invention is new and patentable. That's the basics for this new treaty. Thanks for listening, and until next time, I'm Adam Diament, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.